Would I be right, Mr. Dos Santos, to say that I could say the same of your position that you just said to Mr. Rossellini? You said he would have every mixed question turn into a de novo question, but would you have every mixed question be given substantial evidence review?
No, Your Honor, I think you could look at the way that this court talked about it in U.S. Bank. Not all mixed questions are alike.
So what kinds of mixed questions would not get substantial evidence review with respect to these matters?
With respect to what, I'm sorry?
These matters.
So I don't have any examples to give you in that respect. I think a lot of what is done is going to be factual in the immigration space. If there are legal questions that turn on interpretation of a particular definition, like a reticulated definition, and the primary work being done is interpreting, looking at a statute, looking at structure, looking at legislative history, and so on, which is not what's at issue here. I mean, then it looks more primarily factual. The other thing I'll say is one of our arguments is that Congress treated this as factual. So if there were evidence that Congress treated something else as more legal, then that would cut the other way. But I mean, here, if you look at Section 1158, Congress said—
I don't get that argument, I have to say, Mr. Dos Santos, because it seems you have some good arguments in this case, but honestly, none of them come from the text. You have good history arguments, you have arguments about the Urias-Zacharias case, but 1158, just because we call an IJ a trier of fact, you're going to read that to determine what the standard of review is?
So several—
I mean, if you just said that we don't give substantial evidence review to legal questions, if we took your textual arguments seriously, we'd have to give substantial evidence review to legal questions too, because after all, 1158 calls the IJ a trier of fact.
So I think what we're saying about 1158 is the thrust of the way Congress thought about the refugee question, is someone a refugee, is that it's primarily factual. And so the way that it described the way that an applicant sustains the burden, that's the title of the provision, to show that they're a refugee, was by saying that they have to satisfy the trier of fact, not only that their evidence is credible, not only that it's persuasive, but that it's sufficient to show that. And then goes on to say, and the way that the trier of fact does that is by weighing the testimony, weighing the other evidence. And that combined with Congress's codification of Urias-Zacharias, taking that same language and plugging it into the substantial evidence review provision, combined with the history before that, I mean, I think it all just makes clear that the way Congress was thinking about it is these are primarily factual inquiries that the IJ is going to make, that we want to have the Attorney General take care of.